Good morning. Thank you. I'm not Vanita Gupta. I'm Trevor Morrison. I'm the Dean of the Law School and delighted to welcome all of you to the 8th conference of our Center on the Administration of Criminal Law. This year's conference is devoted to reckoning with force, examining the intersecting roles of prosecutors, police, and community in use of force cases. I don't need to tell all of you that this is an incredibly important topic at a really important time. Use of force by law enforcement has become a prominent issue, receiving a great deal of media attention. It's the kind of issue whose significance causes a risk that there'll be a lot more heat than light shed on the issue. But one of the great things about this center, and if I may be so institutionally immodest, this law school, is the capacity we have to convene really important conversations to try and generate real insight, whether or not that equals consensus, at least insight and understanding various points of view and in digging deeply into the issues, and I'm sure that's exactly what will happen today. So I'm really thrilled to welcome all of you to this conference. I'm glad that so many of our alumni are here. This is Alumni Weekend, and so it's terrific that this can coincide with that event as well. And speaking of alumni, among the many terrific speakers we have in the conference today are a number of NYU Law graduates, including Vanita Gupta from the class of 2001, and Milgram from the class of 1996, and Bahar Azmi also from 96. That means they are celebrating their 15th and 20th reunions. The dean can't help but say that. So thank you and congratulations. My last function this morning is to introduce Rachel Barkow, our Siegel Family Professor of Regulatory Law and Policy and the Faculty Director of the Center. Rachel, I'm sure, is known to many, if not all of you, as a really nationally leading scholar on criminal law, administrative law, and constitutional law and related areas. She's also a spectacular teacher in these fields, but she's not just a scholar in the sort of theoretical sense, but does amazing work applied in the world. This includes having been appointed in 2013 as a member of the United States Sentencing Commission. Since 2010, she's also been a member of the Manhattan DA's Conviction Integrity Policy Advisory Panel. Rachel is one of those scholars who brings her scholarship to bear on important issues in the world, and this conference is just one more manifestation of that. Educated at Northwestern and Harvard Law School, she clerked for Judge Silberman on the DC Circuit and then for Justice Scalia on the Supreme Court. She's a spectacular teacher and thinker, as I say, so it's a great pleasure to welcome Rachel.
Thank you all very much for coming out today. I get the best part of this conference, which is to welcome you to it and to kick it off. It's our 8th conference here at the center. And before introducing our first speaker, I just want to give you a couple updates and some pieces of information. So first, this is our first tweeting conference for us. And so if you would like to tweet any of the things that you're hearing about, we have a hashtag and everything, but we're not so cool as to realize that it's too long. But if you want it, it's hashtag NYU CrimLaw 2016. So yes, that's 15 of your characters right there. And the other thing that I'm here to tell you about is that thankfully you can ask questions throughout the day at the end of each panel and at the end of the keynotes as well. And Deb Gramiccioni will tell you more about the logistics of that, but start thinking of them because we would like you to participate in the day's events as well. So I want to give you a little update about what the center has been up to quickly as we start. So Deb Gramiccioni, our superstar head of the center, and really an amazing team of students who are part of our center, have been doing incredible work since we saw you last. So we've had 2 cases at the Supreme Court in July. The center and attorneys from Paul Weiss filed a brief in Montgomery versus Louisiana. That was the case that the Supreme Court took to decide whether or not Miller versus Alabama should be retroactive, and Miller versus Alabama was the case that held that mandatory life without parole for juveniles was unconstitutional. So Montgomery was asking whether or not that ruling would apply to people who were already serving their sentence. So they got their life without parole sentence before Miller was decided. And our center filed a brief tackling the question of whether the Supreme Court even had jurisdiction to take up the question, which turned out to be a really important issue in the case. And thankfully, the court agreed with the center's great brief, found jurisdiction, and did, in fact, apply it retroactively. So we were very excited about that. And just last week, on April 4th, the Supreme Court granted cert in another case involving the center. Once again, Deb and her team, this time with lawyers from Boies Schiller, filed an amicus brief urging the court to take this case. It's Pena Rodriguez versus Colorado, and it involved statements made by a juror in the case, racist statements made by a juror in the case. And the Colorado Supreme Court, in a 4-3 decision, said, we just can't consider those. We're not going to look at the statements that the juror made. And the brief that Deb and her team filed argued that, in fact, the Sixth Amendment should require trial courts to consider evidence of racial bias expressed by jurors in the deliberation room. So we're looking forward to seeing how that case progresses in the Supreme Court, and you can stay tuned to that. In addition, the center has remained very active in federal clemency. So if you follow our work, you know this has been a commitment of ours for quite some time. And it continues to be. Last summer, Mark Osler from St. Thomas and I established something called the Clemency Resource Center, which is within our center here at NYU. It is generously funded by Open Society, which allows us to have 7 full-time and 1 part-time lawyer dedicated to doing nothing else but file clemency petitions on behalf of federal inmates to try to take advantage of the initiative that President Obama announced to get more people commutations who are currently serving excessive sentences. So we're really fortunate to have Aaron Collins at the helm of the CRC. And between the CRC and the folks that we've had at the center working on clemency all along, Deb and her team and Nancy Hoppeck before her, we've had 5 cases already granted clemency by President Obama. 3 of those individuals had been serving life sentences, and 2 of them had been serving sentences of 20 years. And they got their sentences commuted. In addition to that, again, the combined efforts of this group, we've now submitted more than 50 petitions that are pending with the Office of the Pardon Attorney. And, fingers crossed, when I see you next time, I'll be able to tell you about many, many more grants in these cases. In addition to that, we're also looking at other cases that don't meet the Department of Justice's stated criteria, but they certainly have meritorious arguments, and so we're trying to find relief in those cases as well for those people. In addition, last week, Deb and Mark Osler were at the White House for their big clemency event, and they continue to urge, as do I, the White House to continue doing the great work it's doing in granting these petitions as quickly as possible. There's still a long way to go to get to all the people who deserve clemency, and we stand ready to help in any way we can to help process those cases. Finally, I'd like to tell you about another project that we're starting, this one with Covenant House, to try to survey some of the young homeless people there to get a sense of what their interactions have been like with the misdemeanor system so that we can learn more about it and how it affects their lives more generally. If any of this is interesting to you and you are a student and you are a 1L or a 2L, we're also looking for fellows for next time, so we encourage you to apply and think about it. We're always busy working for justice at the center, and we'd love to have your help. But if you're thinking about someone who's busy working for justice, you would be hard-pressed to find someone who is busier and more successful doing it than Vanita Gupta, who is our first speaker this morning. President Obama appointed her on October 15th, 2014, to lead the Civil Rights Division at the Department of Justice. So she is the chief civil rights prosecutor in the United States. And in that role, she has done amazing, amazing work. I can't list it all or we'd be here all morning, so I'm gonna highlight some of my favorites. She spearheaded the investigation of Ferguson's policing and court practices. And my own personal favorite, if you haven't read it yet, I really encourage you to do so. She recently co-wrote a letter to the chief judges and court administrators in all of the states, warning them about practices of taking fines and fees from impoverished defendants to raise revenues. It's a really important letter, and we're so grateful that you highlighted the issue. Under her leadership, the Civil Rights Division has remained active across the range of critical areas that it's responsible for, including advancing constitutional policing and criminal justice reform, prosecuting hate crimes and human trafficking cases, promoting disability rights, protecting the rights of LGBTI individuals, and combating discrimination across the board in education, housing, lending, and voting. And none of this, if you know Vanita, is new to her. She has been devoting her entire career to this kind of civil rights work and successful from the get-go. Before she joined the Department of Justice, she was the Deputy Legal Director at the ACLU and its Director of its Center of Justice. She also worked as an attorney in the NAACP Legal Defense Fund, where among other achievements, she successfully led the effort to overturn wrongful drug convictions of 38 individuals in Toledo, Texas, and help negotiate a $6 million settlement on their behalf. Most importantly of all, after graduating magna cum laude from Yale University, she got her law degree here at NYU, where she also taught a civil rights litigation clinic for several years. And she really does represent everything we hope our graduates will become, and so we're so happy to have her back today. Before President Obama had appointed her as the head of the Civil Rights Division, Attorney General Eric Holder had named her as the acting head, and when he did so, he said this about her: "Even as she has done trailblazing work as a civil rights lawyer, Vanita is also known as a unifier and consensus builder. She has a knack for bridging differences and building coalitions to drive progress." She is a really special individual. The country is so lucky to have her serving in the role she's serving now, and we're so grateful that she's here today. So please join me in giving her a very warm welcome to NYU.
I should just sit down. Anything after that introduction is going to be a total disappointment. Good morning. Wow. Usually when you start these conferences, people start to trickle in between 9 and 11, and this is a great room. So thank you all, and thank you, Rachel, for that most lovely introduction. We have a Mutual Admiration Society going. I also just want to thank the many law enforcement leaders, the law students, the researchers, the advocates that are in this audience today. I think really not only for the expertise that you're going to be sharing with us today that we're going to be engaging in, but also really for the passion and the service and the integrity that you bring to this work each day that you do it. I want to thank also NYU Center on the Administration of Criminal Law, which is doing really trailblazing work on some of the most pressing criminal justice issues in the country. NYU is really fortunate to have the talented group here, and I'm really glad that the law school is supporting the center because it's so incredibly important. I actually don't think that there could be a more timely set of issues that we'll be talking about today, and I'm really pleased that a few of my colleagues from the Civil Rights Division are also going to be here today. Robert Musi, who was the chief of our criminal section for many years at the Civil Rights Division, who I asked to join me in the front office one of my deputies, is here, and you'll be hearing from him on the first panel. And then Christy Lopez, who is one of our deputy chiefs in our special litigation section, a real leader in our police reform work, and to the extent that I get credit for Ferguson, she really should get credit, her and the career lawyers who day in and day out are providing incredible creativity and vision for the work that we're doing on our policing issues, on some of the toughest issues we have around the country today. So it's just a really amazing opportunity for me to be here. So I joined the Justice Department in October of 2014. And really, for the last many months, our nation has been engaged in a very important national dialogue about police practices, about community police trust, about racial justice, about public safety, about officer safety. And around the country, controversial officer-involved shootings have set off protests, have set off unrest and outrage. Cell phone videos of particular incidents have gone viral on social media. They continue every day. Every day you open the paper, every day you watch TV, there seem to be one more and one more and one more. Tragic deaths, especially of unarmed young black men and women at the hands of police, ambushes and assassinations of police officers, and widespread community mobilization have really brought policing issues from the periphery for too long into the center of our public dialogue. And yet, as you are all well aware, these conversations actually are not new. There is a tendency for folks, I get asked a lot, what is driving this in the last year? And but the reality is, for many of us who have been doing this work, and for communities that are experiencing the things that they've been experiencing for a long time, these conversations are not new. And they're not just a response to high-profile incidents. They really are, I think, the latest stage in our decades-long public conversation about effective self-governance, about public safety, about the promise and pursuit of justice, and evaluating critically the relationship between law enforcement agencies and the communities they serve, particularly in communities of color and particularly in low-income communities, I think really has always been a key part of that dialogue. Now, many people in communities of color and communities that are living in poverty and others perceive our courts and our police and our correction systems as arbitrary and biased and unfair. And these perceptions undermine the legitimacy of those very institutions and really, I think, place the public, place the law enforcement personnel, place the well-being and health of those communities at risk. And I think it's really important to say at the outset that what I hope doesn't get lost in this conversation is that the overwhelming majority of women and men who serve as police officers do their jobs in very difficult and sometimes dangerous situations with honor, pride, and distinction. And we know that the vast majority of police officers want to be perceived as a part of their community. But I also know that law enforcement and other members of the community right now, leaders in the community, communities all over the country, are feeling a real sense of urgency at the moment to rebuild trust and to address what have been long-standing, often systemic, deeply rooted, entrenched systemic issues. In both law enforcement and the communities that they serve, discussions about the use of force include strong emotions and profound pain. And I meet regularly with mothers and family members of loved ones who've been killed at the hands of police officers. I've also met with officers who've been very seriously injured in the line of duty. And according to the Washington Post, last year in the United States, police fatally shot 990 people, 30% of whom were not armed with a gun. According to the most recently available FBI data, 51 officers, including 2 of New York City's finest, died as a result of felonious incidents in the line of duty. So today in our communities, we can see this conversation about the use of force unfolding against really a backdrop of other policing practices, such as unlawful stops, searches, and arrests, that can result in deep resentment and great mistrust between law enforcement and the communities that they serve. And the real question is, what can we do? What can law enforcement and advocates and researchers and community members and civil rights leaders and academics do about these very, very serious issues? How can we actually seize this moment when the nation is actually paying attention for once to a problem that frankly has existed for quite some time, where there is widespread engagement and focus to build a framework for real and lasting reform that really makes our communities and our officers safer for generations to come? It's important to start really any conversation about police use of force by recognizing, of course, that our constitutional democracy endows police officers with the authority to use force within limits. A fair, transparent, and equitable criminal justice system is one of the strongest pillars of this nation's democracy. And police officers are at the front line of that system, and the authority that we give police is among the most profound in our constitutional form of government. Courts measure this power against legal standards, and police departments measure this standard against both legal standards and often professional standards. And increasingly, with video and changing technology and social media, the public is measuring this power against community values and priorities. More than 2 decades ago, in Graham versus Connor, the Supreme Court established objective reasonableness as the standard for evaluating when law enforcement can be held liable for using excessive force against civilians. And the court acknowledged in that case that objective reasonableness does not translate into a precise definition or mechanical application. It requires an individual analysis of various factors in each case, including the severity of the crime, the imminence of the threat, and the subject's resistance to arrest. And in the years since, federal courts have provided additional guidance about how to apply the legal standard of objective reasonableness. Where police officers violate the law, prosecutors have the ability to hold them accountable. And you'll be hearing from state and local prosecutors throughout the day, but I want to talk for just a minute, and you'll be hearing from Robert Musi about our federal authority in this realm, but I just want to spend a minute talking about our federal prosecutorial authority, which is quite different and much more limited than state prosecutorial authority. So for decades, under two federal civil rights statutes known as Section 241 and 242, the Civil Rights Division has conducted thorough and impartial investigations of individual officers for criminal violations of constitutional rights. And this means pursuing criminal charges when the evidence supports us doing so. And during the last 7 years, we've charged more than 400 defendants for committing willful violations of constitutional rights under color of law and related offenses. But it also means closing cases when the evidence doesn't support charges. And in use of force cases, federal law requires us to prove both that the officer used objectively unreasonable force and that he or she acted willfully for the specific purpose of violating the law, one of the highest standards of criminal intent. And I will tell you, and all of you know this from following the conversations over the last many months, that there is a real mismatch between community standards and expectations of what people think the law should be versus what the law allows for. Now, many prosecutors right now around the country are wrestling with very thorny questions, and I think you're going to be having really robust discussions on these panels coming up, but really thorny questions about how to promote transparency while protecting the integrity of investigations. Because the public is demanding a lot of information in the age of video when there is a little bit more information out there, but the prosecutors may have more. They're asking about the role of the grand jury process in a particular case. They're asking why investigations are taking so long. They're asking about how best to close a high-profile investigation when charges can't be brought. And you've seen probably an array of different ways that state and local prosecutors have chosen to do that. They're asking about how to proactively educate communities about the strengths and limits of applicable laws in the criminal investigation and prosecution process. Now, among prosecutors, just as among police officers and other law enforcement, the heightened public focus on use of force has really triggered, I think, important in tricky conversations about professional standards in a changing world. Now, criminal prosecution, while very important, really represents a limited tool to achieve accountability. In 1994, Congress gave the Justice Department, in the aftermath of the unrest in LA, they gave the Justice Department an additional tool: the Civil Enforcement Authority to determine whether a police department is engaging in a pattern or practice of constitutional violations, and if so, to remedy those violations. And the Civil Rights Division conducts fact-driven investigations to determine whether policing practices, including the use of force, are comporting with the Constitution and federal statutory law. And when we find a pattern or practice of conduct that violates the Constitution or federal law, we work with the police department in question to bring about real reform, transformative, sustainable reform to that community. And where we have to, we can resort to litigation and have resorted to litigation to remedy those violations. In most instances, we are able to negotiate with the police department to achieve a court-enforceable, independently monitored consent decree. And those consent decrees can also serve as a blueprint for reform efforts around the country. And I think the consent decrees, the recommendations that are in the President's Task Force on 21st Century Policing, the recommendations in the COPS Collaborative Reform process, the initiative, these are all things that can really help police departments and the rest of the community initiate dialogue, conduct self-review, and take action long before the Justice Department intervenes. Now, as officers face an endless variety of situations, including sometimes very dangerous conditions and contexts, week in and week out. There's no question that Graham versus Connor doesn't provide the full guidance for officers. They need additional guidance to really understand what objective reasonableness means and how it relates to practical decisions that they're making every day on the street, how to apply force, when to apply it, decisions like whether to wait and strike or fire. And clear policies and robust training and effective supervision can provide those necessary guidelines. Effective police departments help officers translate the legal standard that is in Graham versus Connor by ensuring that they are receiving the proper training and instructions about what it actually means to use objectively reasonable force. And these departments train their officers in how to exercise their power and discretion lawfully, safely, and responsibly. Through our more than 2 decades of work in this field and engagement with law enforcement, with communities, with policing experts that are both within and outside of the profession, with professional and evaluated best practices in law enforcement, the civil rights division's agreements around the country, including in New Orleans and Cleveland, Seattle, Portland, Albuquerque, and Ferguson, and just last week in Newark, they advanced a set of key principles and practices for law enforcement agencies to employ. And we really believe that these principles and tactics can help officers avoid excessive and unnecessary force, including tragedies that can tear a community apart, and that while also ensuring officer and community safety. And the approach is going to sound quite simple, but I will guarantee you that there are times where that it isn't fully accepted, and I think that is really changing right now. But this approach begins by declaring an unwavering commitment to protecting human life and upholding the dignity of all individuals. To advance that mission, and it's detailed in many of our consent decrees, we aim to ensure that police departments adopt and follow the following principles. Use force only to accomplish a legitimate public safety objective. Use de-escalation techniques to minimize the need for force and increase the likelihood of voluntary compliance. Use force in a manner that avoids unnecessary injury and escalation to officers and civilians. Never use force to punish a person or to retaliate against criticism. And when officers do use force, they should immediately render necessary medical care. Following the use of force, police departments have to ensure accurate reporting, adequate investigation, and for where incidents of unreasonable force, discipline, and in appropriate cases, referring cases to prosecuting authorities. Specific guidance from police departments can help translate these principles of de-escalation and respect for the sanctity of human life into practice. And often, this guidance is actually set by the profession itself or by professional association best standards, standards that I will say regularly set above the legal requirements to better protect both officer and public safety in tense situations. Through our agreements, we promote guidance that incorporates, with some exceptions, a series of clear tactical rules, including bans on chokeholds and on shooting at moving vehicles. Other rules involve carefully limiting the use of tasers in drive-stun mode as a compliance technique, as well as not tasing pregnant women, children, and other vulnerable communities. From guiding principles to specific rules, de-escalation embodies a critical approach for officer and community safety. By buying time, creating distance, keeping space, and calling for backup, officers can expand their options. Now, I recognize no situations are identical, and each one's going to require situational awareness and context. But de-escalation training and clear policies can actually increase the likelihood of safe outcomes in potentially dangerous situations. And they demonstrate a commitment to the sanctity of life and how it affects decision-making in the field. I also think that there are thousands of times when officers manage to safely resolve tense and volatile incidents. And I was going to show a video today, but it was going to be a little difficult, so I urge you actually after this conference to go on YouTube and pick up this video from Camden, New Jersey, back in the fall. And Chief Scott Thompson is here and maybe even talking about it. But it is a video that stands in marked contrast to some of the other videos we've seen about what de-escalation really looks like. And it's a video about a man who was mentally disturbed, who had a knife, and kind of what the process was over the course of many minutes in a de-escalation context that resulted in no use of unnecessary force and safety for the officers and the individual involved. Now, I will say also, we don't hear about a lot of these stories, and I think that they are important for us to be able to lift up and amplify, even as we are witnesses to some of the other more shocking videos where life is taken. There are also a lot of situations, and I'm not naive to believe that de-escalation is going to work in every single context. And officers confront a whole range of situations every day in which they're going to have to exercise their discretion. And sometimes officers respond to situations where, consistent with legal standards, the use of force is both justified and necessary to protect officer and public safety. And I think everyone in this room understands that. But there's another element to this which is actually outside of what happens in the street every day between officers and community members. And some of that has to do with officer support. I think we need to do a lot more to support officers in the field. These are stressful jobs. They're often encountering very traumatic incidents, and they need to have access to counseling, to mental health services, and other support to ensure officer wellness and future appropriate interactions between officers and the community members that they're working with. And I think officers also deserve support and training to use de-escalation on the job. It requires training. It's what separates me from the police officers that are doing this work every day in terms of the fact that they need to get the training to be able to promote the de-escalation tactics and strategy. And that support is going to include crisis intervention training. You know, daily officers encounter people in crisis, including people that are struggling with mental illness. In fact, yesterday, the Attorney General said what I think we all believe, which is our criminal justice system has become a warehouse for people with mental illnesses. And daily, police officers are encountering people in crisis with alcohol and drug addiction problems, mental health problems, anger management issues, all social problems that, frankly, we have overused our criminal justice system for. And these are problems that a lot of officers never envisioned they would be spending this much time on. And that's a reality of today's policing in our criminal justice system around the country. And as a society, we share a collective responsibility to address these issues by ensuring that individuals in crisis receive appropriate care from medical professionals and social services, not just being put into jail facilities with no access to adequate and appropriate treatment. And officers are often the first responders in these incidents where family members are reaching out to the police department to get help in crisis situations. And so even as I think public support for diversion and community-based interventions are on the rise and expanding, we owe it to officers to ensure that they're getting the training that they need to recognize the challenges like mental health conditions, language barriers, hearing impairments, drug use, and the like. Crisis intervention training and CIT officers can help address that need. We've seen the impact of this approach in Seattle. And Seattle is a city where we've had a consent decree for a number of years. A federal monitor recently found that the Seattle Police Department's new crisis intervention policies, training and operations are in initial compliance with our agreement. And the monitor praised officers, and it was a long road to get here, but praised officers for interacting, quote, compassionately and with an eye towards treatment with those in crisis. And the monitor cited a story of two officers who had arrived at the scene of an intoxicated individual who was in crisis and who was holding two large butcher knives in each hand. And the officers withdrew from the apartment, safely created distance, established communication with the subject in question. And the subject later, over time, followed instructions, and the officers were able to place the subject into custody without additional resistance from the subject and without exposing themselves to undue risk. And these are some of the stories, like the one in Camden, where you can see that on video playing out in real time, really where the monitor praised these officers for working together to protect both each other and the safety of the subject. And one of the things, I was out in Seattle a couple of months ago with the Attorney General, where we were evaluating the progress on the consent decree, and I saw that the crisis intervention teams that have been established since our consent decree started involves people from the mental health community and the police department sitting around the table and really regularly meeting about individual cases, having mental health professionals arrive on the scene in real time when police are encountering a person in crisis. It's a whole different paradigm that's being used now. And the force principles, though, that I've been discussing here are not only going to help law enforcement stay on the right side of the constitutional line and avoid unnecessary tragedies, but they're also going to build trust with local communities. And we know that when it comes to how residents see their government, procedural justice really matters. People want to trust the police, and they need to trust the police, but they want to be respected in their daily encounters with the police as well. And decades of research shows that fair and respectful treatment matters sometimes just as much as the ultimate result of one's interaction with the police. Surveys that have been conducted of law enforcement in the community over time during the life of our agreements, we do community-based surveys. They're pretty scientific, at the start and throughout the course of our agreements. They really demonstrate how constitutional policing builds trust in communities where sometimes it has felt like there was no turning back, that things were so broken and the problem so entrenched, and we've been able now to document really transformed relationships over time. And frankly, At the end, that allows for officers to feel like they can be co-creators with the public. The community is willing to share information, to serve as witnesses, to provide information about crime. And in the end, frankly, it inures to the benefit of everyone to have that amount of trust, because it's where trust is so broken that you will see a real reticence in those communities about being willing to speak to the police about what's happening in their communities. And police officers will be the first ones to tell you that. Of course, we also, in our consent decrees, value transparency, and I think transparency is a really key part of this. Data collection. We need data collection and we get it in our agreements to help review and evaluate all of the trends around use of force in this country. And I think we need to have accurate and consistent data from across the country, both on excessive force and on officer-involved shootings, to really better understand the trends and numbers behind these issues. And the Justice Department recognizes this, and we're continuing to work closely with law enforcement to develop national consistent standards for collecting this kind of information. And I know there's a lot of work right now at NYU as well with folks engaged in that effort. Now, one issue is body cameras that's been in a lot of news, and the division has encouraged law enforcement agencies to consider using body-worn cameras to demonstrate transparency, to document evidence, to deter inappropriate actions by officers and by the public. And preliminary studies have shown strong evidence of improved officer community engagement and reduced civilian complaints following the implementation of a body-worn camera program. But look, we all know, and I mean, in the aftermath of Ferguson, there was a rush towards the body camera issue, but we all know that body-worn cameras are not a panacea. Other studies have demonstrated that video from cameras can't be relied upon to present a definitive account of any encounter, and their adoption alone isn't going to cure deeply rooted problems related to accountability and trust between law enforcement and the communities they serve, but it is certainly an important tool. So we focus on all of these things in our agreements, and we're continuing to see tangible results and signs of success. And, you know, in Los Angeles, which was one of our first jurisdictions that we were in after we got the '94 statute, independent researchers from Harvard University wrote this in 2009 about the tangible benefits for officers and residents alike in the years following our consent decree, which dealt directly with problems of use of force. It said, since 2003, as the police use of force declined, so did crime. And as police-community relations improved, even in the poorest neighborhoods, so did public safety. In Detroit, after about a decade with the police department under a consent decree, we found improved training and revised use of force policies help lead to a nearly 60% decline in the average number of officer-involved shootings per year. In Seattle, a federal monitor examining a 3-month period found that officers used force in only 2% of roughly 2,500 encounters with individuals in crisis. And in East Haven, Connecticut, where the police department revised nearly 85 policies in 1 year, residents continue to report transformed relationships with their police officers. And so we believe in these use of force principles, and we think that they've been successful around the country. But we also recognize that right now there is a passionate and intense discussion taking place about the use of force. From Ferguson to New York to Chicago to Baltimore, we can see that discussion between law enforcement and the communities they serve, as decades of mistrust have been ignited really by high-profile incidents and crowds have taken to the streets. And we can see that discussion within the police community itself right now, as chiefs and sheriffs, command staff, line officers, and union officials are wrestling with the tough questions that are needed to build consensus around reform. We can see that discussion among prosecutors, as I said, as they're trying to balance the need for transparency and the integrity of investigations. And we're also seeing it among advocates, among traditional civil rights groups who are meeting with a new generation of activists around what are the appropriate ways to demand change. And every day we're seeing these discussions unfold. I am in a lot of rooms right now where I'm having these discussions with all stakeholders every day. But I think that sometimes in these discussions, while passionate and intense, there's a tendency sometimes to forget that there isn't that much disagreement on some core principles. And that's regardless of whether you're in law enforcement, you're in the community, you're an advocate or an academic. One is, we want to and need to reduce deadly encounters. We want to keep families whole. We want to respect human dignity. We want to support and strengthen officer safety, and we want to rebuild trust between police and communities they serve. Those are just some fundamental precepts that I think everyone, regardless of where they are, is agreeing to. But yeah, we're struggling right now about how to bring these, bring us to these ends. And I think there's seriously no question that there is a lot of struggling in communities all over the country around these issues. And we might debate about which principles are going too far, which principles don't go far enough. This is the bottom line, that we can't fight this discussion because this discussion is happening. We have to embrace this discussion and this dialogue. And to the extent that there are people who feel attacked, that is not the right way to engage in that conversation. We have to embrace the dialogue right now. We have to seize the opportunity. As all of you know, the country and the public have short memories. I will say this is, I think, this particular conversation right now is sustained for a whole host of reasons. And I think that we have to engage in the thoughtful, engaged debate that is actually going to be able to achieve change. It means that we're going to be able to create lasting change on the professions that we love, in the communities that we serve, and in the society that we all live in. And within communities and law enforcement itself, I really do see a commitment right now that is markedly different than 2 or 3 years ago, and maybe others will differ, that is engaging in these hard discussions and is trying to drive progress. And I also believe, though, that we need to include a lot more voices in this conversation. We need to have space, and I'm saying at conferences like this one, for rank and file officers, for union officials, for marginalized community members to actually speak about these issues that they are living and breathing every day. In the Civil Rights Division, my view, we view this whole process of stakeholder engagement as actually critical. It's one of the things, there's a lot that we've learned in doing this work, and the stakeholder engagement piece is so key, because if we are going to have sustained reform in a police department, it can't just be seen as the Justice Department kind of pushing all of these ideas. In the end, change in policing has to happen locally as well. There are certain fundamental characteristics of policing that are extremely local. And during our investigations, though, for this reason, we engage with a whole array of stakeholders over many months. It's part of why our investigations take a while. We're not just looking at documents and data and talking to experts. We are engaging with community members. We're speaking to line officers. We're meeting with union officials. We're speaking with rank and file, command staff, and civil rights advocates. And all of this is strengthening our work. In Newark, for example, we met with rank and file officers. We set up a toll-free hotline. We held community members to gather information from all quarters. And in crafting the reform, we pushed for community input on police policy and a role for residents in ensuring officer accountability. And part of what our agreements do, too, is to create structures over time by which the community will have a way to have a say-so in the kinds of policies and trainings and priorities for their police departments. And on a personal basis, I regularly engage with a whole range of stakeholders, including the International Association of Chiefs of Police, Fraternal Order of Police, the National Association of Police Officers, Police Research Executive Forum, civil rights leaders, other law enforcement leaders, advocates, researchers, the whole list, really to ensure that we're taking into account their expertise and their input as we craft reform around the country. And right here at this law school, I also learned that even if we don't always agree, we have to be able to allow people to speak their minds, to share their ideas and to challenge our views. Because it's at precisely the moments where we do not agree that I always find the discussions the most valuable, the most instructive, and the most insightful. And yes, they take us all out of our comfort zone, and they are hard. But we need to have this dialogue in a sustained way in this country, because the time is now. And I will say, as we engage in this critical conversation, and today and in the days ahead about the use of force in policing, I also want you to know that I am not naive. I've been doing this work for my whole adult life, and I understand the intense emotions and attitudes and challenges that are presented here. But history has always taught us that real change requires embracing those challenges. And more than a half century ago, Dr. Martin Luther King Jr. spoke from the steps of the Lincoln Memorial to remind America of the fierce urgency of now, warning us that it would be fatal for the nation to overlook the urgency of the moment. And so as we continue to lead these tough but critical conversations and reform efforts around the country, around the use of force in policing, may we be motivated by the fierce urgency of now, but also by mutual respect. And may we see this moment of intense, passionate engagement as an opportunity for real change. And also may we seize this moment to really, at the end of the day, make our communities and our officers safer for generations to come. So thank you very much, and I welcome questions.
So we're going to have 2 microphones. We don't have a ton of time for questions, so I would just ask that your questions be on topic, and also we're going to group the questions. So we'll be walking around, and maybe we'll take 3 and then present them to you. Thank you.
Hi, thank you so much for being here. It's truly an honor. And thank you to NYU for hosting this fantastic conference. My name is Rebecca Goldberg. I am currently a New York City Urban Fellow, which doesn't mean so much, except for the fact that I'm also, in that role, a policy analyst at the NYPD. And in doing so, I'm actually working on drafting our use of force policy. So I'm wondering, if you had a blank slate, if you had a whiteboard in front of you, which I'm kind of presented with every day, what would you want to see on that use of force policy?
I have a very specific question on something you said very early in your presentation, specifically about not shooting at moving vehicles, a blanket policy on that. I was wondering how you see that as a civil rights violation, if it's of the driver, and if you're arguing that a vehicle can't be used as a weapon, or if that is only for the threat of surrounding, other people in the surrounding area. And if so, then a blanket policy wouldn't cover very remote areas where there is no other folks, especially in a border environment. So first, why it would be a civil rights violation. Second, blanket policy and how that would enact with remote areas, especially in border environments. Thank you.
Good morning. My name is Joe Rossinello, and I was the U.S. Attorney for the Northern District of California and San Francisco from 1982 to 1990, and again from 2008 to 2010. And in that earlier era, the big difference in civil rights cases, and we had cases of excessive use of force, is that the FBI would generally defer to the local agency's investigation. And we, as the Department of Justice, would consider whether or not there was a thoroughness in the investigation before announcing that we were, undertaking a civil rights inquiry and possible prosecution. What's changed, it seems to me, and what's aggravated the situation, and especially agitated law enforcement, is that almost immediately, with the announcement or disclosure that there's been some incident, the Department of Justice is in there announcing that it's conducting the investigation. So I'm curious as to whether you have developed any information, gotten any data that suggests that rather than helping, that's actually hurting the process.
Okay. Thanks for all of those questions. I'll do my best to respond. So just on the de-escalation, the use of force policies, I think it's really important to be able to review the policies that have been put in place in the police departments that we've been in. I named some of the principles and tactics, but those provide a lot of detail. And it's as I said, these are really complex issues. And so, I'd be probably boring everyone if I started to read out from a consent decree, but there's a lot in those agreements, and a lot, frankly, that our agreements don't cover that police departments are producing after we have a decree. So our agreements are saying that there needs to be de-escalation tactics that are offered, the training that's offered to police officers, and then we'll work with the police department, the monitors will work with the police department about, what kind of training that is, and across a whole array of use of force practices. And so I would just urge you, just in the interest of time, to actually look at our agreements and look at what some of the police departments have put in place in the jurisdictions that we've been in that get into a little bit more granularity than some of the principles that I just spoke about today. I got a question about this blanket policy around not shooting at moving vehicles. So I will say that there are, and I would love, I mean, maybe Chief Thompson will speak about this later too, but there's a kind of widespread best practices among police professional associations about, that has been evolving over time about not wanting to create undue risk for officers and citizens. And shooting at moving vehicles is one that can be very prone to creating that risk. And there are a lot of, again, this Fourth Amendment inquiry is always very factually based, but our agreements provide that is not a good best practice, that it has been studied and evaluated, that a number, in fact, we are there, it's not DOJ leading that, I think that's really the profession that has across the board really recognized that kind of situation creates undue risk for everyone involved. And so that is in our agreements, but it's also something that is very much a widespread practice now in policing. And on this last point, so actually, and for those of you who don't know, obviously, well, you may know now in the light of very high-profile shootings, we do typically defer to state and local still. The vast majority of our cases, it is actually more the anomaly for us to open an investigation before the conclusion of a state or local investigation. It is part of our U.S. Attorney's Manual. You will know probably of a few instances where that did not happen, and those are usually very considered and deliberate conversations that we have with the highest level of leadership at the Justice Department. But actually, our typical practice in the vast majority of cases is to defer to the state and local. Sometimes the FBI will assist in the investigation and provide federal law enforcement assistance of a particular incident. But it is why you will see that, the people will say, well, why did DOJ take 4 years to come to a conclusion? Well, it may be that 2.5 to 3 years of that we're allowing for the state process to play itself out. And so that's actually our typical process even today. Thank you very much.